Thanks for joining me for my banner. And for a country of some 25 million people in excess and having only 300 or less of judicial service judges, that is as serious as it can be. But these have connotations to justice delivery. And what does it mean? We have with us regular panelists, president of the Legal Foundation, we have Dr. Maurice Ampao, and he is the president for the Legal Advocacy Foundation. And thanks for joining me, Maurice.
Thanks, my brother.
All right. If a justice of the court comes out and says we have less than 300 judges in our country, what does it mean? Does it mean that we have, if you take the lower and the superior courts, we have 300, all of them, including the magistrates?
Yes, I think the judges was right. He was right by saying that, look, if you take all the judges in the country, given the cost structure,
the number,
right from the Supreme Court,
the number up to
less than 300. And these are the men and women who we have entrusted the administration of justice to. And he's saying in the context that this put a lot of strain on justice delivery. So we know we always say that justice delayed is justice denied. So he's trying to say that, look, when it comes to administration of justice and we want a quick way of administering justice where you will not have so much delay, don't blame the judiciary. Blame the system that you have put in place. Previous governments have failed to expand the structure of the courts. They failed to recruit more judges into the system, and that is causing the delay. And so he was looking at it from the human resource. If we have only 300 men to administer justice in all the countries, then it's a big problem. Because if our population is almost about 20-something million, and you have 300 people administering justice, then there's going to be a challenge.
At what point do we say that there's not speedy adjudication of justice?
Oh, definitely. Normally, when you go to court and you have a case, you want the case to be adjudicated in a way that, one, it will not put too much stress on you. You know, one, you've committed money. When you file your processes at the court, money is gone. Then you know the cost of transportation to the court. And then you have situations whereby you have so many adjournments of cases. And you have a simple, can you imagine somebody's owing you 1,000 Ghana cedis, that's owed 10 million cedis. And then you decide to take this person to court. And the person has no defense. He owes you. But then when you file the writ against the person, the system itself helps to frustrate you. Because the system says that if you file, do everything possible to serve the person. So if the person is not being found, you have the writ for almost about 1 week, 2 weeks, the person is not being saved, you cannot proceed. Now, then the person now decides to go, you go and file what we call substitute service. You go to the court and tell the court, my lord, we are trying all effort to save the person, you cannot locate the person, so give us another way by which to save. Then you go and then the court grants you the substitute service. This one at the court notice, one at the residence of the person, and then one in the newspapers. And that normally the court will give you about 21 days. After the 21 days, then you come, then you have the person now appearing to defend. Then he tactfully look at the rules and procedures and file some technical defense, raise unnecessary issues that the court have to go into. And the volume of the cases is such a way that we will have one judge having more than maybe 20 to 30 cases in a day to handle.
That's in excess?
Excess. Some of them have 60. As much as 60 cases to handle in the day.
Such scenarios, how do they put a strain psychologically on the judges?
Psychologically, our judges are having a lot of challenges, and if they are watching me this morning, they know. I've done a little bit survey among some of the judges that are closer to me and friends, and out of 5, about 4 are having BP, high blood pressure. Our judges are sick. They are not well. In fact, there's so much pressure on them because, one, the cases keep on piling, and there is a system in place where they have to deliver judgment, and then the judgment are being monitored by the CJ's office. And you have, as you are hearing cases, more is being added. Some of the cases are very technical. Some lawyers make it so much difficult for the judges to proceed in trial. Some lawyers file unnecessary papers Others fail to come to court. Others give all kinds of excuses. Others connived and collude with the court clerks and the registry, and even to get a docket missing. You know, some of them come early to mention the case and go. There are so many mafiaism in the practice, in the system. Practice. So it's at times very frustrating. And then there's another way which frustrates the judges and causes a lot of delay. No, anytime you want to proceed in court, you must serve your opponent. You must put your opponent on notice. And that is where the challenge is. At times they believe. The court believe who's going to serve the process. You file the process, you pay the belief fees and everything. The person will not go and serve. Only for you to maybe travel from Kumasi to Accra. Only to come and meet that there's non-service of the process. The court cannot proceed. Because if he proceeds in law, he has done what we call breach of natural justice. It then means that in law, that day he doesn't have jurisdiction, the power to hear the case because the other party has not been notified. And all these things are delays. And then you have systems also where some judicial services staffs and lawyers at times even steal documents from the court docket. You know, they remove.
That's all part of the process of delaying.
I'm telling you, delaying. And then you have.
So these are the underhand dealings.
Underhand dealings. So the delay is not only about the number of judges, but the system itself. At times, the rules also, the rules also is so technical and all. Look, let me give you an example. When you file
it's technical. It's supposed to be technical.
But it's delayed. For example, if you file a case right now, and then the lawyer has 8 days. The person has 8 days to enter appearance. He can wait to the 8th day, then he file a paper called conditional appearance. And the conditional appearance, he needs 2 weeks to file a motion to set aside your paper. The person can intentionally file a conditional appearance for 2 weeks, and then he will then leave it like that. Then when you file a paper to get judgment, he then file a late defense. And then in the defense, raise so many technical issues. And then even, let me tell you, after you have gotten judgment in our courts, executing, getting the results, like what is happening in the Woyomi case. You know the AG has been given 30 days to recover all our monies. These are matters that have gone to court. And up to now, we have not seen no recovery. So you get judgment and you cannot enjoy the fruit of your labor.
These things that you're citing, how do they frustrate the worker and the judges already when they are in limited numbers?
The judges, one, are frustrated because most of them are ready to deliver justice, but the rules causes a lot of delay. 2, some lawyers are not cooperating. And then 3, at times the litigants themselves. It will surprise you that there are some litigants and parties who will never go to court without trying to see a judge. And that's what happens. Instead of them trusting in the justice system, trusting in their lawyers, they want lawyers to go and see judges for them. So they will give money to lawyers and tell the lawyers that go and see the judge. We believe that that's the only way we can get justice. And all these things frustrate the judges. And most of the times, these judges are innocent. They are not aware of this money being given. Then you have some lawyers and some middlemen, either clerks and then the registry, taking money in the name of the judges, and these judges don't know whether this money has been given. And all these things create a lot of system and a lot of delay in the system. And I think that it's a big challenge. So when it comes to delay, it's not only about the number of judges, but let's look at our procedure, the criminal procedure, and then the civil procedure, how we proceed. Number 2, let's look at cleansing the system, especially the belief system. It is so frustrating. Because if a belief wants to frustrate you, he will not go and serve the paper. And once he doesn't serve, there's an adjournment. Then we have parties also who don't come to court. Parties who don't have case, and then what they do is that they keep on changing lawyers. And then we have a situation whereby we have so many holidays in the system. You know, we just started the court process and we will just resume from long vacation in October. Now, next month, we are going for Christmas break. And then we resume January. Then Easter will come. Then after Easter, then we go to the long vac. So you realize that we have so many holidays. And these holidays affect. And then also, some of our judges also are not strong in terms of health. And then if you have a court system which is not conducive, the courtroom itself There are so many challenges. The air conditions are not working. If at times if you go to a judge chamber,
hot.
Apart from hot, like classroom table, it's sad. And you see, at times you go to a judge chamber and then quickly you realize that the judge confidence has gone down. Because if you look at the other person's own office compared to a whole almighty judge, and the chamber has nothing, no air condition, no fridge, and then hard a table, hard chair.
But the judges are paid well. They could fix their own thing.
No, the judiciary must fix that one. So we are not making their work very comfortable. Some of the courtroom, when it rains, they have to stop. And in Accra, if you go to some of the courts outside Accra, the proceedings are held in somebody's chambers under a tree. And these things are happening and all over. So we have not invested so much in the administration of justice. The infrastructures are not there. So we are lacking when it comes to investments in the judiciary. And that's exactly what we need to do.
How do these inadequacies and inefficiencies influence outcomes on judgments?
It's simple. When you have a case which is delaying, some of the cases, some land cases, almost 30 years. Some of them 40 years.
In the courts?
Yes, in the courts. One judge comes to narrate.
Adjournment?
Adjournment, and then through a delay.
Transfer of the cases to the next.
Yes, at times a judge handles a case for about 7.
A judge may recuse himself out of a certain case.
Definitely.
And all
a judge starts a case, maybe then he's transferred. And then it comes, starts all over again. And then at times some people also bring petition against the judge. The case is transferred here and there. So you may have some cases travel as long as almost 30 years. And when it happens like that, what happens? You realize that frustration and fatigue have set in. And then some judges at times even forget the evidence. You know, the evidence is written, but in law you also have to look at the demeanor. So if you didn't witness the demeanor and you are going to write judgment, it will affect. So, and then at times when you have a case that is delayed, then the evidence is being destroyed because witnesses now you cannot have your witnesses, and then most of the things are not contemporaneously; they are not fresh in your memory. So now you go to court and you want to remember some of the things that happened. And then, you know, most of these land cases where it involves traditional history, you know, and you have a judge who is a typical Ashanti judge in Accra, and they are mentioning normality, you know, the names and the trees. The
non-familiarity with the case itself.
Yes, so difficult situations.
Do they have, in many jurisdictions around the world, they have libraries and they have where they can always go get data and literature? Are judges also privy to those sorts of resources?
Oh yeah, we do have. We have the various libraries at the law school. We have.
No, not that in the other courts. Do they have them?
Oh yeah,
what they want to do.
Oh yeah, they do. They do have. Some of them have their own private library, and these days the modern technology can even access some information. We have the e-library, and then we have. So they have access. That one, there's no problem. But the problem is the number, the volume. You know, if you're a judge and you have about 100 cases, and then every day new cases are being added to, you see the frustration. You are not able to dispose of because cases are not yet. And you know, there is always this saying that justice delayed is justice denied. And I also say it, justice hurried is justice buried. If you hurry to give justice, you bury it.
You bury the case
because
quickly.
you need to take time to look at the facts, look at the law, and look at the evidence and evaluate it, and write a good judgment.
The difficulties that the judges are facing, are they creating a disincentive to having perhaps young lawyers or experienced lawyers to enter the bar?
Oh, definitely.
To be part of the
bench. Yeah, definitely. Because one, their conditions of service are the best. And then, you know,
so it's better you're in private practice?
Yes, we lawyers make all the money and then we go and file papers at them. Their conditions of service are the best, especially the lower courts, right from the circuit to the district. It's not the best. And then also, they don't have a social life. Judges don't have social life. That's why they have a lot of challenges. They have socialized. They are antisocial because of the nature of the way. They don't need to mingle. Their code of ethics doesn't allow them to go to club, chill, you know, and move around and down. When it comes to lawyers, we have this big social life. Lawyers are known to be social beings. We chill, we travel, we do so many things.
You guys are socialized.
Yes, we socialize. But judges, you need to conduct yourself, you need to hold yourself up, and You don't even have, sometimes you don't even have friends if you're a judge. Yes, because if your friend, a friend is coming to you, it's as if he's going to influence you. And then you know they have also difficulty that judges go through is the difficulty of delivering just judgments, because when you're going to do judgment, one party will lose, one party will win. And then the person who will not win will begin to read all kinds of meanings, and some of them also spiritually take on the judges. And it's a difficult situation for them. And then we don't, some of the society also don't appreciate the difficulty. The transfer here, petition here and there against them. Some of them are false, some of them have no basis. And then there's the problem of also the Chief Justice at times being hard on you, monitoring you, reprimanding you, transferring you and there. It's not easy for the people to be on a bench, but they are coping. But I think that we need to support.
So what can be done to augment the current numbers?
What we can do is to expand the court structure. Let's build more courts. And thank God, currently we are building a complex at the Cocoa Affairs Court there. It's good. Let's also increase the number of judges into the system. Let's pay them. Let's give them a better condition of services. And also, let's do proper court case management. Let judges manage their cases very well. Those who are doing criminal cases, let them do criminal cases. Specialization comes in. Criminal cases, those who are doing civil cases, those who are doing adoption, those who are doing divorce. But you have to go to a court, one judge is doing criminal, civil, adoption, everything, jack of all trades.
So in other jurisdictions, that's not the case?
Yes, they are specialized court. And then you have a situation whereby...
Just like the way we have fast track and all that.
Some judges don't know even when some judges don't manage their cases very well. You go to the court and they tell that, oh, they are in chambers doing divorce. And the whole day they are doing divorce. If you know that you do divorce, why do you want to do a criminal case? So you don't miss criminal cases and divorce, because even the psychology of it, when you're doing divorce, it's more emotional and social. Then criminal cases also have its own level of temperature. And so we need to manage our cases very well. And then we are praying also for the Chief Justice to understand that these judges are under stress. They are human beings. They have challenges psychologically and emotionally and things. There are so many things there. So you should also understand that they are human beings. They have weaknesses and then normally appreciate their
so
challenges.
By so doing, and then we tend to augment their numbers, then we can improve the current state of judgment.
Justice in the country.
Okay, I just wanted to run this by you before you go. A Court of Appeal judge, Justice Mrs. Gertrude Tokonu, said there's very little judges can do when private citizens, with the active connivance of public servants, embezzle or steal from the state through dubious claims. What do you understand by this very statement?
Yeah, what he was trying to say is that judges are constrained, especially when they are not supposed to interfere in people's cases. They are neutral. They should be neutral. So when you have a situation whereby somebody takes on the states and then he makes a claim, and then instead of the states defending the claim, he comes and says that we don't have a case. We want to settle. And then they go and settle and bring the settlement.
So the state, you mean they are represented by
the state attorneys
from the Attorney General's department?
Yes. So when they connive, there's this collusion to rob the state. It's very little that a judge can do, because you file a case against the state comes and tells the judge, my lord, we want to go and settle. They take it out of court settlement, and then they come and say that this is how we've settled the matter. And then we also have others, the state will come and put up a weak defense. They will do admission, and then the other party files judgment on admission. You see, but another way by which judges are able to also go into, judges should not only look at the case presented by the plaintiff against the state, they must look at the claims and then also begin to inquire into the evidence. Let them probe a little bit. And then I think the judge who made this statement was applauded when I think he resisted some judgment. Yes, because he looked at the evidence and realized that, look, although the state don't want to defend the suit, he thinks that the plaintiff doesn't have a case, and he refused. And then the Supreme Court commended her. So I think that it's a duty on our judges not only to look at the claim and then look at the defense, but they must go beyond and find out why is the state not putting up a very good defense. And then we need a monitoring system where state attorneys will be monitored on a little bit basis. When they file defenses to actions, let's have the senior state attorneys monitoring them. And then I think that the last thing I will say, that let state attorneys promotions and should be based on performance. How many cases have you defended and won for the states? If you are failing, you are not promoted and you'll be fired. And then let's bring in new people who will come and deliver.
Already,
and that's the only way we can
already we don't
state.
have enough.
We have.
All right. Thank you very much. Dr. Maurice Ampao is the president of the Legal Advocacy Foundation. Today we've been talking about justice delivery. More importantly, when it's been out this week that we have just less than 300 judges for the whole of our country. That's a difficult situation, is it not? Next, we will have to talk about the Lancaster University, Ghana, and they are putting together what they call the Business Challenge Cup, and is a unique marketing plan competition designed to challenge high schools and introduce them into the world of business at a tender age, or a young age. When I say tender, not infantile ages, young age. We're taking a break. When we come back, we'll be having a representative of the Lancaster University in the studio, and we'll be having detailed discussions on the subject. Do stay on.